All persons having business before the Honorable Associate Judges now presiding over the District of Columbia Court of Appeals, draw near and give your attention. God save this United States and its honorable court. This honorable court is now in session. Please come to order.
Good morning. Welcome to the District of Columbia Court of Appeals virtual courtroom. We have a full house this morning. We also have two cases that have been consolidated, but per our order from January 10th, I believe, they're going to be argued sequentially. The cases are 20 AA 693 DuPont East Civic Association et al. Versus DC Office of Planning, Historic Preservation Office, Mayor's Agent for Historic Preservation, and 20 CV 315 DuPont East Civic Association et al. Versus Muriel Bowser. Counsel, can you first tell me which case you would like to argue first? I have the administrative appeal on my list first, but I don't know what you all planned to do.
Your Honor, speaking for the district, I think our understanding was that CV 315 would go first, and then AA 693. But if the court would prefer the other order, we're happy to oblige.
Perhaps Mr. Eisenstein, perhaps you could speak to that.
Yes, Your Honor. That's my understanding as well, but I defer to the court if the court wants to hear the second one first. I believe the first one involving 315, there is a pending issue of the districts has agreed to concede or to agree to remand 8 of the 9 claims. So that may, if the court is thinking about entertaining that or deciding that prior to the argument, that may cut a significant amount of the argument in 315, or maybe all of it.
Okay, so we'll start with the CV appeal, and we have fewer lawyers involved in that one, I believe. Mr. Eisenstein, you'll have 15 minutes, and then the district, Mr. Phillips, will have 15 minutes, but perhaps we won't need that much time. So Mr. Eisenstein, when you're ready, if you could introduce yourself for the record and let us know how much time you'd like for rebuttal.
Yes, thank you, Your Honor. May it please the court, Mark Eisenstein on behalf of the appellants, DuPont East Civic Action Association, Nicholas Deladon and Rachel Rubin. I'd like to reserve 6 minutes for rebuttal.
All right, so noted, and apologies for mispronouncing your name.
Oh, thank you, Your Honor. Appellants brought a lawsuit in DC Superior Court challenging the improper conduct by the District of Columbia in approving a project to develop a luxury apartment building on the site of the Masonic Temple, one of the most renowned historic landmarks in the District of Columbia. The lawsuit brought claims alleging that the appellant's constitutional rights were violated and also violations of the DC APA. The claims arise from the Historic Preservation Review Board's revision of the temple's landmark boundaries and also the subdivision of lots upon which the luxury building would be constructed.
Counsel, if you will excuse me, we've read and read about this. Do you oppose remanding the bulk of the civil case to the Superior Court?
No, Your Honor. We agree to remand all of the claims. There's 9 claims. We would agree to, or we asked to remand all of them to Superior Court, given the district's concession about ripeness and injury.
They do not concede count 9 of the complaint. They say that is not justiciable. And why is that wrong? Why shouldn't we carve that out and just send back the first 8?
Your Honor, the 9th claim, which is alleging that the Historic Preservation Review Board's approval of the conceptual design was arbitrary and capricious. The District of Columbia, in their argument and in their briefs, they allege the same issues, that the claim was not ripe and also that there is no alleged injury in fact. But it's the same injury that are alleged in the other 8 claims. 1 is a constitutional violation, and 2, that the imminent injury, or excuse me, the lack of imminent injury. But the construction permit, I believe, cures both the ripeness and the concrete injury argument. With respect to the,
I guess I had a different take on what the district was trying to say. We'll let Mr. Phillips speak for himself. But I thought the district was saying that conceptual design is a preliminary issue. It's never ripe for review. And if it ever is ripe for review, that's a question that will not go to the Superior Court, but rather to this court in the first instance.
Your Honor, the issue is the mayor's agent cannot make that determination. I believe this court does have jurisdiction to hear direct appeals from the mayor's agent, but this claim, the conceptual review claim, is something that the mayor's agent expressly cannot determine. And second,
there is pending an attack upon the issuance of the building permit. And if that comes out of the administrative process, won't an appeal from that come to us rather than the Superior Court?
Yes, Your Honor, but here the allegations are constitutional claims and the DC APA claims, which are separate and distinct, and there's different standards and there's different regulations than in the consolidated appeal.
I mean, but just focusing on the 9th claim, which is not a constitutional claim, it's about whether it's arbitrary and capricious. The HPRB's approval of the conceptual design that then only goes to the mayor's agent. I guess I still don't understand why you think that question, which is preliminary, it's advisory from the HPRB, why that would get Superior Court review absent the mayor's agent's ruling.
Well, I guess, thank you, Your Honor. With respect to the issue of the mayor's agent, I believe we cited to DC Code Section 6-1108C, which specifically says that the mayor's agent shall not make determinations about compliance with conceptual review. With respect to the first question, we understand the district's argument, but the determination was made part of the decision that the mayor's agent relied on. So since that is the case, that is our position about that. This is not a separate injury. This is all part of the same injury. It's one step in the process, but it was made part of the mayor's agent's decision and concluding that the approval was proper and that the mayor's agent determination. So that's our response to that position, Your Honor. With respect, would the court like me to address the? I'll address the larger issue, which is the Superior Court dismissed this case based on a finding that the Historic Preservation Review Board had primary jurisdiction. And we believe that is wrong for a number of reasons. One, at the time that this decision was made, the Historic Preservation Review Board had already made their determination. So if the Historic Preservation Review Board had primary jurisdiction, the proper remedy would have been to stay the civil lawsuit until the determination was made. But since the decision had already been made, that would be improper. Two, these are constitutional claims. The 9 claims at issue allege violations of the appellant's constitutional rights, as well as the DC APA. That is not something that's within the expertise of the Historic Preservation Review Board or the mayor's agent. These are claims that are fit squarely within the court's jurisdiction in DC Superior Court. There's no mechanism for a Historic Preservation Review Board or any agency to make a determination on constitutional claims. One that
I agree with you there. So let me, I don't know what my colleagues are interested in. I can only speak for myself. I don't think there's any real question that the Superior Court, in my mind, erred in saying that they're, in not addressing these claims. And the district has since given up its ripeness and standing defenses that they've offered, at least as to 8 of the 9 claims that were raised. So just, unless my colleagues want to delve into that a little bit, I guess I'm curious on your views about how it makes sense to proceed with these 2 appeals that are now kind of just a mess. One thing, I think you're asking us to send the CV case back down, hold the AA, the administrative appeal, in abeyance. That's your position?
Yes, Your Honor.
And if in the remand of the CV case, the Superior Court upholds the boundary line determination, that would leave, what then? What do you, I'm just trying to figure out where the efficiencies lie and how we address these two appeals.
Yeah, Your Honor. We've been grappling with the same issue. I believe one, discovery is not closed, so I don't think a direct remand. The case would need to proceed. There would need to be additional discovery, and it may be some time before. I assume the district. I believe both parties will move for summary judgment, so I believe that'll take some time. But in terms of what to do about the administrative appeal, I'd probably defer to my co-counsel, Mr. Hayes, who may have a better idea about kind of a mechanism of avoiding the inevitable issues that Your Honor pointed out if this case is remanded.
Now, the permits have issued. I assume, I don't know what we have in the record before us in terms of what's happening on the ground right now. I feel like with the permits being issued, I assume things are being built in a way that it doesn't strike me as obviously in your interest for us to sit on the administrative appeal. So can you explain to me, if building is underway and why it is you want us to wait on the administrative appeal?
That was something Mr. Hayes was prepared to argue, if that's okay with the court. But I believe construction, yes, but we agree. Construction has started, I believe. Digging has commenced. This is not kind of this is a real construction site. So would the court like me to defer to Mr. Hayes to answer that question?
We'll ask him when it's his turn.
Okay.
I don't want to cut you off, Mr. Eisenstein, but perhaps it makes sense then to hear from the district now.
Yes, Your Honor. Yes,
to get their views.
Yes, unless the court has any questions, yes.
Mr. Phillips.
Good morning, and may it please the court, Graham Phillips on behalf of the district appellee officials. So DECA's lawsuit in the Superior Court challenged two actions by the Historic Preservation Review Board. The first was the HPRB's determination setting the boundary of the temple landmark. And the second was the HPRB's conceptual design review approval of the subdivision and new construction that the project will entail. As we've explained in our 28K letter, we agree with DECA that the challenges to the boundary determination are now justiciable, and so we do not oppose remanding that aspect of the appeal to the Superior Court. We of course strongly disagree that with them about the merits of those challenges to the boundary determination, but we agree that the Superior Court can at least reach those merits. In contrast, the claim challenging the HPRB's conceptual design determination remains non-justiciable. And that's so because, as this court has already held, a HPRB conceptual design determination is not a final agency action, is not binding, and therefore is not ripe for adjudication before a court. That is precisely what this court said in the N Street Follies decision, which is squarely on point. It's directly about this issue of I'm sorry.
Mr. Phillips, are you saying, number one, it is not ripe, and number two, it will never be ripe?
Yes, but if I can explain that a little bit more.
Please.
The conceptual design determination was not ripe and never will be ripe, because that determination is not final agency action. It does not fix any rights, duties, or legal obligations, and it is not the consummation of the administrative process. So because it is not final agency action, it's not ripe and never will be. Now, the sort of underlying substantive dispute about whether subdivision and new construction are consistent with the purposes of the Act, that certainly does become ripe, but it only becomes ripe after there has been the relevant final action on the permit application, the subdivision, and then the new construction application. So as for subdivision, that became ripe after the mayor's agent actually decided the subdivision question. And that dispute is the subject of the second case that we're going to be arguing here today. As for new construction, that became ripe after DCRA issued the building permit with the mayor's agent's approval for new construction. And so the proper way to challenge the new construction aspect is by challenging the building permit. To the best of my knowledge, DECA just didn't do that, hasn't done that. But in any event, even if they had, that would not make the HPRB's design review determination subject to judicial review. It would just mean you get to challenge the relevant substance in that separate lawsuit, which is not what's before the court. And
So sorry, just to cut to the chase, Mr. Phillips, your point is, look, to the extent that they're concerned that this conceptual design determination, which you say isn't final and isn't binding and doesn't create any rights or obligations, to the extent they're concerned about it being relied upon, they should attack the thing that relies on it, which is the building permit.
That's correct, Your Honor. That is the source of any actual injury that they're suffering here, is that final determination. And so that is the appropriate agency action to challenge insofar as you want to dispute the consistency of this building with the act.
If I understood correctly, your 28K letter, that building permit is now being challenged before the BZA, is that correct?
That is correct, Your Honor. It's being challenged there on zoning grounds. So,
okay.
DECA has, they also have zoning challenges to both the subdivision and the construction permit that they have raised in their BZA appeal.
And did you say a minute ago that they have not challenged the design of the building?
To the best of my knowledge, no, they have not. I am not aware of them having filed a case that challenges the construction permit as inconsistent with the Preservation Act. I mean, obviously, if I have just missed something, I'm sure that my friends on the other side will let you know.
When we entertain zoning appeals, all sorts of things come up. When the zoning protest, loosely couched, comes before a court, will it come to us rather than the Superior Court?
I believe yes, Your Honor. I confess I'm not 100% certain. I haven't sort of read up on that exactly, but I do believe that the decision by the BZA in that case will be a contested case that will come directly to this court. I think that's correct.
Can you just talk to me as a practical matter about why we would decide? Let's assume I agree with you that the challenges to the mayor's agent's decision are not meritorious, at least not as they currently stand. But things would change quite drastically if the Superior Court litigation on the boundary line dispute goes their way. So as a practical matter, why does it make sense, or how does it make sense? How would we even review the administrative appeal? There's this kind of big elephant in the room that could drastically change what the mayor's agent did on the boundary line dispute, and we just don't have a resolution of that yet. And frankly, I mean, I know this is a lot and not even phrased as a question, so indulge me and maybe just give me your reactions. I'll stop there. I guess I just kind of want to know what the practical concerns are about how we handle these two appeals, assuming that I generally agree with you on the administrative appeal, but that the Superior Court one needs to go back.
The question is, what are your thoughts?
Sure, I have many, and I'm happy to share them, and I'll try to do so in a coherent order. But there are quite a number of pieces, I think, that go into thinking about this question of the interrelationship and why you should, in our view, proceed with the administrative appeal. So, I think the argument for holding the administrative appeal in advance would make a lot of sense if deciding it now was really going to sort of shut the door on DECA in some kind of unfair way. But we have agreed, and it was decided by the motions panel, and we agreed at that time and still do, that if you go ahead and decide the mayor's agent's case and affirm that will not block DECA from going back if the boundary is changed and asking the mayor's agent to reconsider that decision. So that door will not be closed in some sort of permanent or unfair way. So that's one piece, but that's only one piece, I recognize. I think a big part of this comes down to—
Can I pause you right there, though, and say, I take it that there's sort of this conceptual agreement that, if they were to prevail on the boundary line dispute, they could go back to the mayor's agent. But what about sort of, boots on the ground concerns about what's actually happening on the site? Does that play into our consideration?
I think it can, and I think that is yet another reason to proceed apace with the administrative appeal, because construction is continuing. I think if DECA's arguments about the administrative appeal are right, even under the current boundary determination, then it's in everyone's interest for this court to say so as soon as possible. Now, of course, my position is that their arguments are wrong. But if the court is going to disagree with me, I want the court to say so as soon as possible, to allow the situation to just continue and for construction to continue. If it's the case that the subdivision is legally erroneous, that's not good for anyone. So I think that's one reason why.
Yeah, I mean, no, for sure, counsel. That is why I tried to posit, assume that I agree with you on the merits of the administrative appeal. I think it's absolutely clear that if we thought there was some reversible error in the administrative appeal, whatever the boundary line is, we better take care of that now. No reason to wait. If we think the administrative appeal is kind of dead in the water unless the boundary line dispute goes their way, that I think is a little bit harder for me to conceptualize. I mean, I take it what you're saying is, well, look, they can, through one mechanism or another, we've conceded they can reopen in front of the mayor's agent. I'm not really sure what that mechanism is or how we'd write an affirmance that says, but feel free to revisit, or this has no res judicata effect if they try to reopen. I'm not really sure the mechanics of it. Do you have a view on that, sort of what that disposition of the administrative appeal would be without closing the door to reopening?
Sure. So I guess the best place, we discussed this in the abeyance briefing of a year ago, and there we cited the regulations, the mayor's agent's regulations that allow for reopening, and acknowledged that if the boundary changed, that would be grounds for requesting reopening. And and we also expressed our view that preclusion would not apply, which I think is correct. And then this court in its order said, in any event, you have essentially thereby waived the defense. So I don't think there's really any mechanical problem. And as for this court's decision, if it were to decide now, I don't think this court would need to sort of leave the door open in any way. I think that it doesn't sort of need to do that in order for the mayor's agents proceeding to be reopened if there is a change of circumstances that would get you around preclusion, as we concede it would. And in that earlier briefing, we analogized to Rule 60B practice in courts. And there it is settled that even if a judgment has been affirmed on direct review, that does not prevent a Rule 60B reopening of the judgment after that affirmance on direct review if there are changed circumstances. And so that's the situation we'd be looking at here. But maybe I can, so that's the mechanical side of things, but maybe I can say some more about additional reasons why I think it would make sense to go forward, even if, as you posit, Judge Deal, and I hope you will agree, that we should win in the administrative appeal. And there are really two components to that, I think. One that I've already sort of mentioned briefly is asking what's the likelihood of success in the boundary determination in the Superior Court. Because I think it's undisputed that holding the administrative appeal in abeyance could only possibly have some sort of efficiency benefits if the boundary changes. So I think that squarely invites you to look into the likelihood of the Superior Court succeeding in challenging the boundary. And we've briefed that to some extent, and I think the answer is that the odds of the boundary changing are very, very low. And I'm happy.
If we said something like that in an opinion, wouldn't that unfairly impact the civil case that will address that issue before the Superior Court?
I don't think it would unfairly impact it, Your Honor. It might impact it, but to my mind, that's no different from when this court, for instance, rules on a preliminary injunction decision. In that context, you opine about the likelihood of the merits in the underlying case.
But in a preliminary injunction situation, isn't there just more information on the table? I mean, here all we have is a complaint. How are we supposed to assess the likelihood of success in the civil case just on the basis of a complaint?
I don't think you just have the complaint, Your Honor. For one thing, I mean, the complaint attaches quite a number of exhibits. And I think in the administrative appeal, there have been part of the discovery materials in the Superior Court case have been introduced. But the other thing I'll say is I would understand the court's hesitation to say anything that seems sort of factually intensive about the likelihood of success. But there are a number of basically just pure legal issues that matter to the boundary case that I think are fully briefed and capable of being addressed by this court, if it wanted to do so. And again, I'm happy to talk in as much depth about those merits issues as the court is interested in. But the other thing, just getting back to why I think it makes sense to move ahead with the administrative appeal, the government of the District of Columbia has an institutional interest, a broader institutional interest in getting a faster decision, a prompt decision. We're not asking for expedition, but a prompt decision in the administrative appeal. And that's because that appeal raises fairly fundamental questions about the proper interpretation of the Preservation Act. And the HPRB and the mayor's agent are confronting those issues routinely in many cases that arise before them. And
you're not in the strongest position to be invoking your interests when the reason when you induced the Superior Court, I mean that's a strong word. You convinced the Superior Court of a primary jurisdiction dismissal that you now concede was not in fact a good basis for dismissal. You're just not in the strongest position to be saying, the efficiencies would favor deciding where this mess was partly brought about by your litigation tactics.
That's a fair critique, Your Honor, but that doesn't speak to, to the extent we made a bad argument in the Superior Court case, the issue that I'm talking about now is really all about the administrative case. That's the case that has sort of called into question the manner in which the district has been interpreting the Historic Preservation Act. And, so regardless of what happened in the Superior Court case, those questions would have been raised when they were raised by the administrative case. And our interest in having that case decided as promptly as possible would still exist. So the district wants to know that it's properly applying the act in other cases. And if DECA's arguments in the administrative case are right, or some of them are right, even in part, that matters a lot for how these other cases before the board and the mayor's agent proceed. And I guess the last thing I'll say is that even if you imagine a case that the boundary is expanded, I think it's undeniable that Perseus would continue to argue to the mayor's agent that nonetheless, the subdivision is consistent with the purposes of the act. And so to answer that question, the mayor's agent needs to know how to properly analyze consistency with the purposes of the act, including subsidiary questions such as, can an income stream from a subdivision like this properly count as a historic preservation benefit? So those questions that are teed up for decision here and now by the administrative case, I think are going to have to be confronted by the mayor's agent and very likely this court, regardless of what happens with the boundary. And so I think all of that counsels for deciding the administrative case now in the ordinary course. And I can't see how DECA is unfairly prejudiced. And again, if they believe their own arguments, they too should be very happy with a prompt decision by this court in that case.
All right, thanks, Mr. Phillips. Did you have one other thing that you wanted to say briefly, or?
No, I just wanted to say that I know I've spent a lot of time talking about abeyance and not the ripeness and issues. And I'll just leave it on the fact that I think the N Street Follies case, which DECA has never addressed in any of its filings, is squarely dispositive of the conceptual design determination and the fact that it is not subject to judicial review.
Could I address some of these issues, Your Honor?
Well, I don't believe that you are a party in this case right now. Ostensibly, we're in the civil matter, and we will hear the administrative appeal momentarily. So
I was just going to talk about the abeyance.
Right, and I'm certain that will come up in the administrative appeal. So right now, I'm going to let Mr. Eisenstein have his rebuttal, just a few moments, and then we'll move on to the administrative appeal.
Yes, thank you, Your Honor. I don't think I need all 5 minutes that I reserved. With respect to the district's arguments about count 9, which is the only count that they have not agreed to remand, these are all arguments that would be raised in a 12B6 motion. We're here because the Superior Court dismissed these claims based on lack of jurisdiction. So all we have to do to survive a motion to dismiss is allege injury. And given that fact, I believe that our complaint addresses these issues sufficiently, and any technical arguments about failure to state a claim or whether these are non-justiciable need to be resolved by the Superior Court and need to be remanded. Given,
I don't know if they're not justiciable. I don't know why we'd remand that for the Superior Court to opine on that again. Do you want to address N Street Follies?
Your Honor, I don't believe N Street Follies. One, here we're alleging DC APA violations. I believe the confusion is attacking the substance of the decision that was made versus the constitutional and administrative claims that result from the decision. That's what we're attacking here. We're not aware of any case that says that is not a claim that can be brought and should be brought in Superior Court and resolved by.
I mean, if it's arbitrary and capricious decision making that goes to something that is not reviewable, like the HPRB's conceptual design review, because that is just not a final decision that is subject to review. I don't understand how that gets you out from under N Street Follies.
Yeah, Your Honor, our position is one, this is an argument, again, respectfully, I don't believe that DC Court of Appeals has the jurisdiction to make that determination. I think that needs to be made by the trial court. I don't believe
we don't have the what? We don't have the ability to say what's justiciable before the Superior Court. If you guys brought a claim that said, if this is nonsense and has no business being in front of the Superior Court, why don't we have the authority to say that?
I believe it first needs to be addressed by the trial court.
It definitely doesn't. I mean, we can address, we can say that the trial court has no jurisdiction to address this claim. Why? That's a purely legal matter. Why would we need the trial? I mean, there are some prudential reasons why we might want the Superior Court's input first, but it's certainly not a question of what we can and can't do. You're saying you don't think we can say whether or not HPRB conceptual design review is not proper subject matter for the Superior Court to review. You don't think we can do that in the first instance?
Your Honor, I've not kind of exhaustively researched the issue, but it's my understanding that claim would first need to be brought in the DC Superior Court.
Assume we can address it in the first matter. Do you have a substantive response to why N Street Follies doesn't say that you were wrong, that this is not a reviewable matter?
Not different than I've already articulated, Your Honor, that one, this is it. Yes, not that I.
All right. Well, I think we will conclude there with the administrative appeal. With the civil appeal, I apologize. So that case will be submitted. We will move on to the administrative appeal. And now I need to know what the order of operations is going to be with Mr. Eisenstein and Mr. Hayes. My understanding is you have 15 minutes jointly, and how are you going to split that up? Or is one of you going to speak take the whole time?
Yes, Your Honor, I defer all my time to Mr. Hayes for this appeal.
Great, that makes it easy. And then Mr. Phillips and Mr. Ronan and Mr. Zamidi, am I pronouncing that correctly? How are you all going to divide your time?
Your Honor, we were going to split our time evenly, 7.5 minutes. I'll go first, and then Mr. Ronan will take 7.5 minutes. And I believe Mr. Zamidi he represents the Supreme Council, but was not intending to argue.
Great.
That's correct, Mr. Phillips. Thank you.
Thank you for the clarification. All right, Mr. Hayes, when you're ready, if you could introduce yourself for the record and let us know how much time you'd like for rebuttal.
Yes, may it please the court. My name is Michael Hayes, and I'm arguing the administrative case on behalf of the petitioners. And I would like to reserve 5 minutes for rebuttal. So shall I proceed, Your Honor? A question about the abeyance motion, is that going to be heard after this, or how is that going to?
I think
This is all part of it. Oh, sorry.
Work that into your argument.
All right. Well, let me just address the abeyance argument for just a couple of minutes first. As Judge Deal said, the boundary dispute is the elephant in the room in terms of the case, the administrative case. The mayor's agent relied on that in determining that the requirements of the Historic Preservation Act were met. We believe, obviously, that the Superior Court is going to come out and redetermine that. And we've submitted in the abeyance motion some very powerful evidence and undisputed evidence regarding, among other things, the district's admission that they applied the act in a manner to us that they had never applied it before. We have a statutory interpretation case. We've asked for an injunction compelling the district to recognize Lot 820 as the boundary, and that would make a significant difference in your Honor's review of the mayor's agent case. The other thing that's disturbing, which has been alluded to by the court as well, is the practical effects of the mayor's agent case being resolved prior to the time that the Superior Court case is resolved. And we pointed out a couple of the instances where, for example, I'll take an example from Claim 9. The mayor's agent relied on the boundary determination of the HPRB, which is challenged in the 9th claim. So we've been directly injured by that determination by the HPRB's conceptual design.
The 9th claim might not be your best claim to rely on if we agree with the district that it's not judiciable.
Well, the issue of that is whether or not we've been injured by it or not, right? I mean, if we've been injured by it, it's I think justiciable if we've been injured by it. Their claim is that we have not been injured by it, but the mayor's agent specifically relied on the HPRB's determination as to compatibility in rendering his judgment.
So, that sounds like it might be a basis to challenge the mayor's agent ruling.
Well, it is.
Does it sound like an independent basis to go and seek Superior Court review of the HPRB's conceptual design review that was only informative to the mayor's agent?
Well, we are challenging that compatibility determination, but he relied on it, and we're caught in a bit of a catch-22 situation when the order that we're challenging is not going to be resolved until after your Honor's rule on the mayor's agent case. So that's essentially the problem that we face.
We're talking about whether or not it makes sense to hold any decision on the administrative appeal in abeyance, right? pending the litigation of the civil case. And you said, look, the mayor's agent clearly relied on this. So, I mean, what do you think about the district's argument that we should be evaluating the likelihood of success on remand?
Well, I don't agree that the court is in a very good position, as I think Judge Deal said, or you said, Your Honor, as to what our chances of prevailing are. But I would submit that we have clearly presented a prima facie case that we are likely to prevail on not only the Sixth Amendment claim, the Fifth Amendment claim for equal protection, but we address a couple of the other instances. There's the Administrative Procedure Act, where the district says that it adopts the national bulletins requirements, which say use current boundaries at the time of the designation. The current boundary at the time of the designation was lot 820, which is in fact what the first HPO report found, that the boundary of the temple was lot 820, until they got a call from the developer. And then 4 days later, they issued a revised opinion as to what that border might be, what that boundary might be. So we think we presented, ample evidence that we have a strong likelihood of prevailing on the merits. So that would be my response to Your Honor's question on that regard.
Mr. Hayes, could you address something for me, please? Let's assume purely hypothetically that we go ahead with the AA appeal and your client loses. Mr. Phillips has said, if it turns out that in the civil case, the boundary line was drawn improperly, you essentially start over again with a new procedure before the mayor's agent. If that is true, how are you prejudiced by our deciding the AA appeal?
Well, I think that, we also talked about judicial economy. The court, of course, would have to hear it twice. But as to our position,
excuse me, my concept is that we would hear a different case in the future.
Well, it would be relating to
review of a new mayor's agent decision.
Right. I think we alluded to the practical difficulties that a resolution by this court of the mayor's agent case first, the impact that could have on the Superior Court. For example, on the compatibility determination, on the issue of the boundary, which is going to, there are boundary issues that are wrapped up in the mayor's agent case, including the compatibility requirement. That's an issue in both of these cases. So there could be an unfortunate side effect where the Superior Court is affected by this court's judgment when we haven't had an opportunity to, it might impact our ability to fairly litigate it. There's also a claim.
Mr. Hayes, you're just not speaking my language. So maybe simplify it a little bit for me. In what way would deciding the mayor's agent case prejudice?
Well, the compatibility.
I'm looking at your claims in the complaint from the Superior Court case. Which of those are going to be upset by our deciding the administrative appeal?
Well, I'm worried about worried primarily about claim preclusion, or the effect a ruling by this court, if this court were to affirm the mayor's agent, the effect that might have on the Superior Court's determination. I mean, there are some issues that are in both cases. For example, the compatibility requirement is one. The period of significance, which the mayor's agent determined was to be at the period of construction, that was relied upon by the mayor's agent in determining that there was no historical significance, and that could affect the boundary determination as well by the Superior Court. So there are issues that are in the mayor's agent's case itself that could negatively affect our position before the Superior Court. And those are two examples of it. And
if they're going to negatively affect your position in front of the Superior Court, why don't you want that to happen now rather than later down the road?
Well, we think we're going to prevail in the Superior Court case for the reasons that I've said, and we have some undisputed evidence. If we prevail in that case, then the mayor's agent will have to rehear this matter under the right boundary. And those issues at that point, the period of significance will be determined. The Superior Court, we believe, will determine that, that the compatibility issue in our favor. And under those circumstances, we think we have a much better chance of prevailing here before this court with respect to the mayor, before the mayor's agent, and on appeal if he doesn't rule in our favor before this court. So those
Let me make sure I understand your reference to compatibility. I take it you're referring to whether the proposed building is compatible with the nature of the historic district is what you're referring to.
Correct.
And that depends not at all on the boundary dispute?
No, it does. It does. If
we were to decide that it is compatible, you think that decision would unfairly impact your litigation of the boundary question?
That's exactly correct, Your Honor.
Thank you.
And so those are two examples of how a decision by this court, a resolution of some issues by this court and the mayor's agent appeal could negatively affect our position with respect to the Superior Court. And I would add that we moved for a stay before this court of the mayor's agent appeal in an effort to resolve so that the Superior Court proceeding could so there'd be a logical progression so that the issue upon which the mayor's agent's opinion depended was litigated first in the Superior Court case. This court denied the motion for stay. We are not interested in delay. We didn't cause, as I think Judge Deal pointed out, we're not the ones that caused the delay here. The delay in resolving the Superior Court case lies squarely at the feet of the district, inviting the error by the Superior Court and then abandoning that position, and then now abandoning their contentions with respect to standing. So
maybe I'm thinking too far ahead, but by the time we get done, the building is going to be standing and fully occupied. What happens then?
Well, they're building at their own risk. I mean, this court said when we moved for our stay, this court responded that essentially that they were proceeding at their own risk, that the lot could be returned to its original condition. The same thing happened at the Board of Zoning Appeals. That's exactly what the Board of Zoning Appeals said as well. I mean, they've adopted, they've proceeded at their own risk here, despite what I would describe as machinations before the HPRB, among other places.
Mr. Hayes, your clock is running low. I wonder if you want to move on to the merits.
Let me move on. I'm sorry we got sidelined a little bit on that point.
No, it's the abeyance question is an important one, but I think it's time to shift.
All right. So with respect to the appeal, the mayor's agent so far departed from rational decision making that his order must be reversed. Indeed, many of his findings merely recite the statutory language, and those insufficient findings were unsupported by sworn evidence in most cases. Most importantly, his conclusion that providing a source of revenue through subdivision is consistent with retaining and enhancing the landmark because over time there's a cost to maintaining a historic structure, end quote, will simply gut the act. Under this holding, any project that produces some income meets the Act's requirements. That cannot be the legislature's intent. So for purposes of oral argument,
under your view, could you just explain to me a subdivision that would meet the Act's requirements? I mean, you've kind of said it needs to fulfill these three purposes. It needs to
sure. I mean, there's
enhance and retain. It's historic. How would a subdivision, under your view, enhance the historic value of a landmark?
Sure. I mean, one example of that is in one of the mayor's agent cases that we cited in our brief, where the mayor's agent concluded that the subdivision met the requirements of the Act because it would bring in, because by increasing, by an assembly of lots, by increasing the area next to the historic landmark, it provided further protection for the landmark. So there's
that doesn't sound like a subdivision to me, but maybe I'm misunderstanding. That was a subdivision.
Subdivision includes assembly under the statute. Subdivision includes assembly of land.
How would a colloquial subdivision, not an assembly of land, how would dividing up land ever enhance the historic landmark?
Right. Yeah. The converse of that. If you had say you had a structure that is itself not historically significant, sits on the landmark site. If you severed that for purposes by a subdivision, that would reduce the protections that were on that dilapidated structure, facilitating its removal and protecting the subdivision. So there are at least two examples where it goes both ways. For purposes of oral argument, I will address the following three categories and rely on the briefs for the remainder. The first are the statutory interpretation issues. The second, the deficiency of the order under the well-established DC APA standards. And the third, the order's evidentiary shortcomings. First, with respect to the statutory interpretation issues, the first issue is whether the act authorizes the mayor agent to consider economic factors such as the cost of refurbishing the temple in approving the subdivision. The order's findings of conformance with the act are squarely based upon this proposition, and that's in the joint appendix at 1396. As it pertains here, the act creates two starkly different routes for approval under the act, each with its own specific requirements. The first route is the necessary and the public interest route, defined as consistent with the purposes of the act, which I will refer to as the consistent and necessary route. And this is the route the interveners chose. The court in Gondelman emphasized that securing approval under this route is a heavy burden. The second route is the unreasonable economic hardship route, which the interveners eschewed. In Preservation 1, a case 646 A. 2nd 984, a case brought under the necessary and consistent route, this court explained the difference between the two routes in unambiguous terms. It stated, there is nothing in the Preservation Act that allows the mayor's agent to engage in a balancing of interests, which takes into account such factors as the cost of refurbishing the dilapidated structure.
But Mr. Hayes, I mean, does it matter that the Preservation Act case that you're discussing was a demolition case, right? And so my understanding is that the agency official said, well, sure, you can tear it down because it costs too much to keep it in place. And we said, no, you can't do that, right? But it seems to me if you're doing necessary in the public interest and you're considering that you want to encourage adaptation for current use, that could be expansively interpreted to say, well, you could have some income stream that would encourage you to keep this landmark open, right?
Well, I think
and intact. And so I'm not sure that I guess I've got sort of two questions. Like, one is the preservation case, Preservation 1, I guess, really on point. And two, why can't we interpret the statutory language fairly broadly?
Well, I would say, first of all, that there are principles of statutory interpretation that apply here. The first one, to address your Honor's point directly, is that identical words used in different sections of the statute are to be accorded the same meaning. And this is a bedrock principle of statutory interpretation.
Which words are we talking about?
Consistent with the public interest and the requirements about retain and enhance and adapt for current use. Those words are used the same. The exact same provisions apply under demolition, the demolition provision of the code, as applies in the subdivision of the code. So the principles of statutory interpretation would dictate that they should be interpreted the same way. The other point I would make here is that Preservation 2, which was also a demolition case, our opponents said that, well, the Preservation 1 merely dealt with, a free-floating analysis, but that Preservation 2 didn't deal with that and confirmed that as well. And Friends of Macmillan Park 2 also recited the same language about, that they approved the mayor's agent decision because he was, quote, not balancing the interests to consider these downstream economic effects. I would also point out that it makes no sense under the statute because you have a provision of the code which is the unreasonable economic hardship provision. The Preservation one distinguished those two ways of proceeding. And here, the court said in Preservation one, it said, when the applicant relies on the unreasonable economic hardship exception, excuse me, an inquiry into the cost of revitalizing a building is not only relevant, but required. So what this mayor's agent's decision done is it had removed all of the protections that are provided under the unreasonable economic hardship route, which includes a list of 9 items that they must submit to show that this is really necessary, and instead replaced it with the notion that any income, any project can be approved as long as the, excuse me, as long as there is income to be produced by the project. Any project could receive approval under the act, so long as it produces some income. That cannot be the rule. And the mayor's agent here did not consider whether or not the Masons could pay for this themselves without the income generated by the downstream effects of the subdivision. Without a finding, if the Masons had the money to complete this project without this complete whatever renovations they needed without this project, there would have been no preservation gain achieved by this subdivision. But yet he refused to look at that. So,
well, I mean, I guess, really? I mean, if you have an $80 million renovation project and you can offset that and keep some of the money, like, why doesn't that encourage the adaptation for current use? It also must retain and enhance there are other requirements in the act, but the legislature. Sure, there are other requirements, and the mayor's agent said, well, look, I really think the only landmark here is the actual building, because there's been lots of stuff that happened behind the building over the years. It's been, it's an evolving situation. There were houses there, they got torn down. At some point, a parking lot is built.
Right.
So
Well,
it's
Your
not
Honor,
like he ignored that. He's looking at this as, all together.
Well, Your Honor, as Gondelman said, the legislature put a heavy burden on somebody attempting to achieve a subdivision under the necessary and consistent route. And there are other routes they could have taken here. If they needed the money to generate income so that to make these renovations, they could have proceeded under the unreasonable economic hardship route. They could have done the same project under that route. They could have done the same project, assuming it met the requirements, under the special merits exception, but they didn't choose either one of those. They chose the consistent with a necessary and consistent route. And under that route, as I think Preservation one held, you cannot consider the balancing of the interests in that. You cannot consider the downstream economics effects. Whatever the balancing of interest can include, it cannot include the refurbishing costs, and that's precisely what this mayor's agent order was based upon. And I would add that,
Mr. Hayes, you're over time, but I don't want to cut you off. I know you had, you outlined certain arguments you wanted to address. What do you still need to cover?
If I have the rest of my argument, it's maybe 10 minutes. If I could have that much time. I spent some of the time on the abeyance thing, as Your Honor knows, if that's permissible.
Well, let's try to why don't you sort of touch base and see if we have questions on the topics that you would like to cover.
Sounds fair. The second statutory interpretation issue is whether the Act's requirements are in the conjunctive or the disjunctive, and the related issue of the burden of proof. And recognizing that the mayor's order did not adequately address some of the Act's requirements, the district and the interveners proffer a never before adopted the statutory interpretation that the Act's requirements are in the disjunctive and that the subdivision.
It's not really they're in the disjunctive. It's that when you ask whether or not it's consistent with the purposes of the Act, you look at those 3 purposes and you take them as a whole, which is the most natural way to read that. It is quite bizarre, I think, to read them in the you need to check each of those boxes. If I were to say my New Year's resolution for the year is to get in shape, to eat healthier, and to exercise more, then would buying a Peloton advance those interests? Obviously, it would help me get in shape and to exercise more, even though it doesn't help me eat healthier. Like it would. You'd
have to use it.
I've got to use it, but it helps advance 2 of the 3, and overall, it doesn't hurt the 3rd one. So good enough. And I don't really understand how your reading that it needs to check all 3 boxes makes a lot of sense.
Well, that's what Gondelman said. I mean, Gondelman specifically said that the actions were in the conjunctive.
But I just described something in the conjunctive, that you look at all 3 together, but not that each one needs to be satisfied.
Well, that's not what, with all respect.
What's the language in Gondelman you want to highlight for me?
It said that, I don't think I have the exact, but I can paraphrase it. It said that, or I quoted it in our briefs, which I can hopefully quickly find.
There's this language that we're fond of citing about whether or not the judicial mind was focused on the particular issue. When I read Gondelman, I did not see them trying to disentangle the argument that you're advancing. So if there's a specific hook, I think I'll need it.
Perhaps you could find the specific language when you stand up for a rebuttal.
Sure,
but
sure. That makes sense.
All right. Well, essentially what it says is that it was insufficient to merely show that it retained and enhanced. It must the applicant must also show that it adapted for current use. So it specifically found it, addressing it. It was in the conjunctive, and then it said that in Gondelman that they hadn't met those multiple purposes. And Gondelman also said it was a heavy burden to meet all of these, and that's why essentially saying that that's why the legislature adopted that. So I think Gondelman is directly on point. There are also a number of mayor's agent cases that have said exactly the same thing, and the mayor's agent here addressed those acts in the conjunctive. But in the matter of 626 F Street Northwest, HPA's number 9474, and in the matter of 1801 Connecticut Avenue, HPA number 85447, are additional cases that all have interpreted the act to be in the conjunctive and that they must advance the act's purposes. The language is directly on point. The third statutory interpretation issue is we believe that the preservation cases establish that the subdivision itself and not the downstream effects must satisfy the act's requirements. And we'll submit a brief on that point. I would also note that there are several mayor's agent cases that have come to that same conclusion. Enri Wetzel Archibald Farmstead, SOB-582, and Enri 2501 Pennsylvania Avenue, OS number 91-261. The fourth statutory, fourth statutory interpretation issues relates to the well-established principle that a decision is arbitrary and capricious if it is internally inconsistent. Thus, even if the consideration of downstream economic effects were permissible, the order arbitrarily and capriciously considered only the downstream effects of generating income and not the downstream negative effect of the temple of dropping a massive 65-foot tall building within a few feet. So the order is essentially heads we win, tails you lose. And the mayor's conclusion that he could ignore the aesthetic effect on the temple, which is what he did, is contrary to decisions of this court. I would recite Renault versus DC 676 A second 913, DuPont Citizens versus Berry, and there are a number of mayor's agent cases that have likewise considered the aesthetic effect created by the approval of an applicant. In the matter of 1312 21st Street Northwest, HPA's number 92104, Enri 3020 K Street.
Mr. Hayes, I might suggest that we can look at your brief and see what you've cited. So,
yes.
If you
all right, I'll move on to the second category, then the deficiencies of the order, and I'll address two of them. The first is that no finding that the subdivision itself would enhance the temple. There was nothing. Instead, the mayor's order was based on a stream of income. We submit that that's not correct. But even if you, for the reasons that I previously addressed, but even if you assume that he can consider that, if the Masons had sufficient money to do the renovations without the subdivision, a topic the mayor's agent refused to consider, then the income stream could not have enhanced the temple. And then the third category is evidentiary problems, and there are two of those that I would like to address. The first relates to the committee report, which the mayor's agent relied upon to determining the so-called significant costs of restoration. No reasonable mind would accept the committee report as sufficient evidence to support the mayor's agent's order. Despite the fact that the interveners had the burden of proof on this issue, no witness from the Masons testified under oath as to the scope of the alleged refurbishing or its cost. The committee report itself was not submitted under oath. It wasn't even moved into evidence. The committee report is over 10 years old and temporally irrelevant. Interveners offered no evidence regarding what the current state of the temple might be or what repairs would have been undertaken. And the second and last evidentiary point is that the order was based on false evidence. We submitted the Grunley webpage in our motion to stay. In their opposition, they did not dispute, as the Grunley webpage indicated, that they already spent $50 million and that were completed in 2015. They told the mayor's agent the opposite, and he relied on it. They said that the temple had not undergone any major renovations since the construction over a century ago. And in addition to being, the court can take judicial notice of that in pleadings before this court, the Grunley webpage is also admissible under the Esch exception. And we'll rely on our briefs for the order's compatibility finding. Among other things, the mayor's agent said that the open space was incompatible with the history of with the historic district, but yet when the historic district was founded, when it was created, the historic district specifically incorporated lot 820, which was vacant at the time. So it makes absolutely no sense for him to have concluded that it was open space was inconsistent with the historic district. And I will complete my argument here. Thank you, Your Honor, for your patience.
Thank you, Mr. Hayes. We'll now hear from the appellees. I can't remember who said they were going to go first. I apologize.
I'm going to go first, Your Honor.
All right. Go ahead, Mr. Phillips. Thank you.
Graham Phillips, again, on behalf of the respondent, the mayor's agent. I'd like to maybe just say one more point about abeyance and then move on to the merits of the administrative appeal. And the final point about abeyance that I wanted to make is that Mr. Hayes talked some about sort of what the prejudice would be if the administrative decision appeal is decided before and how it might impact the Superior Court case. And to be frank, I still don't feel like I really understand this at a nuts and bolts level. But what I think what it boils down to, I think, is that DECA is afraid that in this appeal, this court might wind up saying that that substantial evidence supports the conclusion that the eastern portion of Lot 108 is not historically related to the temple, does not contribute to its significance, was developed at the relevant time. And I think DECA is worried that if this court says that the evidence could support such a conclusion, that could sort of make it harder for them in the Superior Court case. And it might, but that's not unfair prejudice. The underlying evidence about this site and its history simply is what it is. And the fact that it can support a given conclusion as a matter of substantial evidence, and that this court might say so, is not unfair. It's a complaint ultimately about just the nature of the evidence. And it's not unfair for this court to say something about what that evidence is, even if it could, make DECA's other case harder.
What about the fear that this court is signaling to the Superior Court what it would like to see in the Superior Court's decision. And the Superior Court would say, aha, I get it. The easy way home for me is to do this, and the Court of Appeals will uphold me.
Well, we would not object to this court saying that it is not, purporting to decide the boundary issues. That I think would be fair. But again, to the extent that this court says something about the nature of the evidence, and that is an unfortunate thing that DECA would prefer you not to have acknowledged about the nature of the evidence, that's not unfair prejudice. And so I don't think this court should be worried about that potential outcome of a decision in this case.
I think it's perhaps more accurate, though, to say that they're concerned that the evidence points in a bunch of different ways, and maybe you could say substantial evidence supports the mayor's agent decision, but maybe you could say substantial evidence points the other direction. But if we put our thumb on it and uphold the mayor's agent's decision, that somehow skews the review in the civil case, right?
Well, I mean, I think to the extent that you say there's substantial evidence for someone to conclude that the easternmost portion of this site was not did not contribute to the historical significance of the temple.
Well, I'll just add too, they say the discovery is still ongoing, and who knows? I mean, maybe there's discovery out there to show that in fact, that this was always, the purchase of the properties in the vicinity was always part of Alexander Pope's plan, right? That he had some l'enfant-like plan for the site, and that just hasn't come out yet. It just seems like I think they would prefer decisions to be made on actual developed facts rather than prematurely. That's what I'm hearing.
Well, I guess a couple of things, Your Honor, maybe the main one of which is that, I think it's also fair for this court to say that, that the evidentiary record in the Superior Court case could ultimately be different. And if it is, then that could matter in the Superior Court case. So I don't think we don't object to if the court feels it needs to sort of caution that it's not trying to pre-decide the Superior Court case. We are quite confident in our position on the Superior Court case in its own right. And so to the extent that this court wants to sort of be extra cautious in how it describes what it's deciding, we would not object to that. And that's fair, that's fine. If the court doesn't have any more questions specifically about abeyance, I'll turn briefly to the merits. So, I mean, I think that, the court's review of a mayor's agent's decision is limited and narrow. And under that deferential standard, the decision here should easily be upheld. The crux of the conclusion was that, this subdivision would cause no historic preservation loss because it kept the landmark site itself completely intact, and because the eastern portion of this site was historically separate from the temple, did not contribute to its significance, and as a historical matter, had been extensively developed during the relevant historical period and was not open space at that time. Frankly, that aspect of the decision is enough on its own to render it to justify upholding this decision under the Act. But then the mayor's agent also reasonably concluded that this subdivision would generate active historic preservation benefits because leasing the eastern portion of the lot would generate revenue to fund.
That part is a little harder, I think, for you, in part because, I mean, do you have a reaction? I think one of your reactions is, this webpage that they're citing to us is extra record material. But if they're right, it was just misrepresented to the mayor's agent that the temple had never undergone a major renovation. And in fact, $50 million in renovations had been completed prior to that. Seems problematic to me. Do you not find that problematic?
Well, I guess my answer is I don't know if we should find it problematic. It seems quite a factually intensive question, and a question that should have been explored at the fact-finding stage of this case, which was the mayor's agent proceeding. But I think even if it's true that some substantial renovation had already occurred by this time, I don't think that really undercuts the mayor's agent's rationale, so long as it is the case that this restoration effort remains ongoing and this revenue stream will facilitate it and help.
Doesn't it matter? I mean, say they said, oh, we need to do $80 million of renovation, but it turns out they only have $20,000 left to do, right? Doesn't that matter? And to the extent that you say that this should have been developed factually before, isn't that a reason that we should send this back to the mayor's agent and say, sure, we defer to you, but you need to have your facts right? And there seems to be a big problem here about what, at least by omission, there seems to possibly have been some misrepresentation about what the actual facts were.
So maybe I can make a couple of points. One is that if you thought this mattered, I don't think it makes sense for this court just to remand now based on this extra record evidence. I mean, I think the proper way for this to have gone is for DECA to have moved to reopen the mayor's agent's proceeding, and they've never explained why, under the relevant standards, they did not or could not have done so. So I don't think they sort of get the benefit of springing new evidence on this court without having sort of gone through the proper stages. And this court has said that even when the new evidence that's been proffered is designed to supposedly counteract dishonest testimony during agency proceedings, you still have to satisfy the standard of due diligence, which DECA has never, sort of even attempted to explain. I guess another point is that, again, we think the outcome here is the same, and that the decision would have to be affirmed, even setting aside the question of the income stream, because the ultimate question just is consistency with these purposes. And the mayor's agent reasonably found that this subdivision would inflict no preservation losses. And that, I think, is enough on its own to require affirmance of the decision.
What's your response? If I understand correctly, the argument is, but wait a second, you should be looking at preservation losses with reference to a certain period of in time when the Preservation Act was enacted. And at that point in time, that's sort of time one, this area was, open and part of a garden and adjacent to the temple and made, part of an integrated whole. And so there is a preservation loss. I think that's what their argument is.
So I don't think there's any support, Your Honor, for the idea that you sort of measure historic preservation losses sort of vis-a-vis either the present, now 2022, or the date that the Historic Preservation Act was enacted, 1979. You judge them with respect to the period of significance of the historical landmark or district in question. And the period of significance for the temple landmark is 1915. And so there's no dispute that at that time, this entire area behind the temple was developed with 2- and 3-story row houses that were not owned by the Masons and had no connection to the temple.
Right. I'm just curious. I mean, do you have authority to point us to for this proposition? Because I'm just wondering why the council would have been thinking about 1950. It just seems like the council might have been, or likely was thinking, well, this is the landscape of the city right now. It has these historic buildings and, landmarks right now. And we want to preserve the status quo as we see it when we look out the window going forward.
So I'm not actually sure if this court has ever confronted that question, but I think every HPRB decision and mayor's agent decision that you're going to find out there looks at the question of historic preservation benefits and losses from this perspective of what is the time period of significance, because that's what we care about preserving. So I think it would be a radical change to sort of switch over to ignoring that and just looking at what the current day status is. And I don't think DECA has ever disputed that losses and gains have to be looked at from sort of the relevant historical perspective. They, of course, disagree with us to some extent about what that relevant historic time period is, and they disagree about, how you should think about it even within that time period. But I don't think on the basic principle.
Does that create some sort of, I don't know, maybe this is just a theoretical issue, but does that create some sort of problem with, the developer picking what historical time period they would want? For example, right, the Supreme Court sits on a site that used to be a boarding house, right? So could someone say, well, it used to be residential, multi-family homes. We'd like to restore it to that. Never mind that it's been the Supreme Court of the United States for about 90 years. We'd like to, develop that property and buy that property. And, could they say, well, we want to look back to 1890 instead of 1930?
So periods of significance are established by the HPRB. That's something that they do. And so it is not something that the landowner or a developer sort of just gets to control on their own, which is part of my response to the argument that DECA has made in their reply brief, that here actually the period of significance is 1911 to 1929. Their basis for saying so is that the Masons in their sort of construction report referred to it that way. But the Masons don't get to sort of control what the historic period of a landmark under DC law is. That's something that the Historic Preservation Board gets to decide. I'll note though, while we're on that topic, that even if you imagine that the period extends to 1929, there's no way that makes any difference to the analysis in this case, because by 1929, nothing of significance had changed about the nature of the site. All that had changed is that the Masons had purchased but not demolished a few of the row houses on S Street next to the temple. So even extending the period of significance to 1929 really doesn't make any difference.
What would you think? Sorry, go ahead, Judge Fisher.
Can you address for me a comment by the mayor's agent that I guess relates mostly to compatibility with the historic districts? I'll characterize it this way. Open space is a bad thing. It's inconsistent with the historic nature of these districts. To my mind, this historic landmark, its appearance has improved dramatically by tearing down all these row houses and creating green space. And is that irrelevant in deciding what we're going to preserve today?
So I think this goes back to what I was just talking about, that you measure historic preservation losses and benefits with respect to the period of significance of the landmark. So I think maybe I'm saying yes to your question, and I don't want to sort of pretend that that's not something that matters to people in the real world. And I understand why people could think that,
So if I may interrupt, I think you're saying, yes, it is a loss, but it's not a historic preservation loss?
I think that's fair. I mean, obviously this is somewhat subjective, but I think I understand why people would consider this a loss. They like the view of the building from the east, and a subdivision will allow construction. I'll emphasize that all we're deciding here is subdivision. We're not deciding the particular design of Perseus's building. but subdivision will allow some kind of construction, and that will have at least some impact on the views. But that's not, as you say, that's not a historic preservation loss, because in judging historic preservation losses, we have to sort of look at what were we trying to preserve about this structure, and that has to be judged from the relevant historical period and sort of what the site was at that time. So I think, as the top side of this argument showed, DECA has raised many issues, and I want to address whichever of them the court has any questions about. I realize I've already eaten up my 7.5 minutes, so I don't want to trespass further on the court's goodwill, but I am happy to answer any questions that the court has.
I think at this point, you have answered our questions, and we will hear from Mr. Ronan. Thank you, Mr. Phillips.
Thank you.
Thank you very much. Good morning. I'm Gary Ronan for Perseus, which is the developer of the site. I have lots of things I'd love to say, given everything that's gone so far, but I also don't want to overstay my welcome, so I'll try to hit the highlights. I would start with 2 points on the abeyance motion, which I think has been covered well, but there are 2 things I think are worth highlighting. The first ties to a question that Judge Fisher asked, I should say, which is, it has to do with the record that's before you. So keep in mind, this is an administrative law appeal. This is an appeal of the mayor's agent's decision on subdivision based upon the record that was before him when he made his decision. That record cannot change and will not change based upon anything that happens afterwards, including a redesignation of the boundary.
That's true, but it could be mooted out. I mean, if there's a redesignation of the boundary, then we don't need to deal with it.
I agree with that. And what would happen is exactly what Mr. Phillips said, which is DECA has the ability to go back to the mayor's agent and say, you need to review this decision. And then there will be a new proceeding, and that will be decided on the new record that will include the new boundary. But the fact that that might happen doesn't provide a reason not to decide this case on this record.
I mean, it does. I mean, it really does. It really does, counsel. I mean, we tend not to want to decide things that don't have any effect. If we knew that they were going to win the CV case on remand, there's no question we wouldn't touch the AA appeal. If there's a chance they're going to win the CV case, there is some prudential reason not to get into an administrative appeal that ultimately isn't going to matter. We like to address cases and controversies, not things that might be cases and controversies or used to be cases and controversies. And that's, but I think it's a hard question. I'm just saying there's no reason to hold off on deciding the AA appeal. One is that, what's before us now might be purely academic. Usually we don't like to address purely academic things.
Yeah, well, I hear you on that, Judge Steele, and that's a fair point. But I would say to you, there are some really good reasons to decide the case now that I think substantially overweigh whatever concerns you have. And those were touched on in part, but largely relate to the practical concerns that I think you asked about earlier in the argument, and that is, it will be extremely helpful. So think about what's going to happen here. There are 2 ways this could go, right? One is the the boundary determination is affirmed in the Superior Court, in which case, if you've already decided the mayor's agent appeal, it's done. The second is the boundary is changed, in which case DECA has to go back to the mayor's agent with a new proceeding. If that happens, it will be extremely helpful if this court has resolved the legal issues that are presented squarely in this case. And what I'm talking about in particular are, number one, should the mayor's agent do a balancing? Is it the net preservation benefit that matters, as we say, and I think as both case law clearly establishes, or is DECA right that you have to do this conjunctive theory that screws up your Peloton? It would be very helpful in that subsequent proceeding from the mayor's agent if the mayor's agent knows the answer to that question. Number two, it'll be very helpful if the mayor's agent knows whether he can consider the stream of revenue to be generated by this project. You can answer that question now. It's fully briefed. It's in front of you. And number three, it'll be very helpful to the mayor's agent if he knows whether he needs to consider as a preservation harm the loss of the views. which the law, we think, establishes that he does not. And this goes to something we were just talking about, which I'll get back to in a minute. But the point is, in terms of judicial efficiency, in terms of helping the parties resolve this dispute as expeditiously and in a way that makes the most sense as possible, it makes, in my view, all the sense in the world to resolve those issues now. We're in front of you, they're fully briefed, they're legal issues that you can and should resolve, and they will only be helpful in subsequent proceedings if subsequent proceedings have to happen on the subdivision decision. So that's what I wanted to say about the advance motion. Unless there are further questions about it, I'm happy to answer them, obviously. Now, on the merits of this case, DECA is just wrong across the board. And I just want to touch on a few of the highlights here. Number one, look at the McMillan decisions. McMillan 1 and McMillan 2, there are two of them. They are crystal clear in saying that the standard to be applied when you're looking at consistent with the purposes of the act is the net preservation. You do not have to find, the mayor's agent, I should say, does not have to find that each and every one of the purposes of the statute is separately and independently met in each case. That's simply not the law. It's never been the law. It's not the right way to read the statute. For your Peloton example again.
Aren't those project of special merit cases?
No, those are consistent with local, it's consistent with the purpose of the act cases. And they specifically say, so if you look at the language in those cases, let me just go to it here because you asked about cases. And McMillan 2 says, this is a quote, net historic preservation benefits are relevant to the assessment of whether an application for subdivision is consistent with the purposes of the Historic Preservation Act. That is a quotation from the case. So they directly address this question. It is resolved as a matter of law. Gondelman does not say what DECA would like it to say. Look at what was going on in Gondelman. What was going on in Gondelman is residential owners wanted to destroy a historic berm that was out in front of their house. So they could put in.
Can I just go back to, you said that FOMP is not a special merit case?
McMillan.
We call it FOMP.
We call
them
FOMP.
FOMP 1, FOMP 2, FOMP 3, FOMP 17.
Because it's fun to say. So McMillan sounds much more sophisticated and we'll use your language. But I thought McMillan was a special merit case. No?
Well, there may have been, so the language.
Right? The 2016 decision is talking about, on page 1038, talking about demolition and subdivision are necessary in the public interest if they're necessary to allow construction of special merit. Right. And then it talks about balancing special merit and historic preservation loss. And certainly balancing in that context makes a ton of sense. But I'm not quite sure why we should be looking at special merit cases in this instance, which is not to say that I disagree with your interpretation of the statute to be read as a whole, but I'm just not so sure that I would want to go so far as to rely on McMillan to do that.
Mm-hmm. Well, fair enough. I mean, McMillan does say in the language I just read that when you're looking at consistency with the purposes of the statute, that's what you should do. And that's I think, my point. But your point is fairly taken. But to go back to Gondelman for a minute, it simply doesn't say what DECA says it says. As I was saying, that's the homeowners wanted to destroy a historic berm in order to put in a driveway and a garage for themselves. The court said that the mayor's agent denied that application. So the homeowners were appealing, trying to reverse the mayor's agent's decision. That's the heavy burden that the court was talking about. And that's the burden that DECA bears in this case. But more to the point about this weighing of the interests, the court in Gondelman actually says, and we cite this language because Judge Fisher, I think it was, asked for language from Gondelman. We cite this language at the bottom of page 23 over the top of page 24 in our brief. And where
is it in Gondelman?
It is in Gondelman. Yeah, that's okay. At page 1245, 1245. And there Gondelman says that the court is going to uphold what the mayor's agent did because the court is this is the quote, satisfied that the mayor's agent's decision gives effect to the entire act in light of its policies and objectives. And then the court says, and that concentration on a single provision in isolation, as the petitioners would have us do, is inappropriate. So Gondelman is telling you, consistent with what we've just said, you're not supposed to just look at a single part of the act, a single purpose, and decide on that basis. You're supposed to look at all the purposes together. Because what was going on there is the homeowners were saying, well, we can prove that this one purpose of the act is satisfied by what we want to do. And the court says, no, that's not enough. You need to show, based upon all the purposes, that that the mayor's agent's conclusion was unreasonable based upon the record, and they hadn't met that burden in that case. So that's what Gondelman.
Is there any limiting principle on your statutory reading? Like if we said, the Lincoln Memorial is on a prime tract of land. I'm sure if we developed that, if we took that down and developed it, the district would get a lot of money for that. A lot of money that could go to retaining and restoring historic landmarks throughout the district. If we had a decision like that in front of us that said, look, the downstream monetary benefits would A, retain and enhance historic landmarks writ large, encourage their adaptation and current use, and C, I forget which one, I missed one. But let's say that it is consistent with the purposes of the act when taken as a whole to generate that money and filter it back through historic preservation efforts throughout the district. Is that a plausible reading of the act, do you think?
Well, first of all, I would say I think that's a great business idea, Judge Deal, and I'm happy to go into business with you on redeveloping that site. Second, I would say that the way that circumstance should play out is there's going to be a proceeding in front of the mayor's agent where all the evidence is going to go in about the historic preservation harms, which would be very real in that circumstance, and the benefits. And the mayor's agent is charged by statute to evaluate those things, weigh them together, and decide whether that project, as proposed, is consistent with the purposes of the statute.
Which is, I'm not trying to disabuse you of it, but your answer is, yeah, it could be.
Yeah, and once the mayor's agent decides, then presumably there would be an appeal of that one, and you would be hearing it. This court is rightly supposed to give substantial deference to the mayor's agent's determinations. And this is a point that I think weighs on DECA's. A lot of DECA's arguments have to do with weight of the evidence and weighing things against each other. And that's not something this court's supposed to touch. This court's supposed to defer to the mayor's agent on those.
But I thought Judge Deal was asking about limiting principles on statutory language, and that is our concern. And it sounds like you think that there might be room for limiting principles in the Washington Monument case, but you'd want us to wait for that case and not impose limiting principles in this one. Is that your argument?
Well, I would say the limiting principle is, there is a limiting principle. The mayor's agent can't just do whatever he or she wants. He or she has to reasonably determine, has to be reasonable, based upon the record before him or her, that on the whole, there is a net preservation benefit from the proposed project, or at least not a net detriment. Now, it may be in the case of the Washington Monument, or the Lincoln Memorial, excuse me, that when that case comes before you, if let's hypothetically the mayor's agent decided, you know what, I never liked that building anyway, let's get rid of it. When that case comes before you, you may say that is not a reasonable weighing of the evidence based upon the record that was before the mayor's agent. So there is a limiting principle, yes. It has to be a reasonable determination, and also
I'm not understanding what the limiting principle is. I mean, just sort of reasonable. It's not reasonable. It's not a reasonable assessment. And I'm sorry for mixing up my landmarks, but I still am sort of grasping to figure out what the core of what is reasonableness turning on, right?
Yeah.
There has to be some foundation for deciding that something is reasonable or not, and if you're saying, look, income stream, it's a reasonable consideration. And so, the more money you get, seems like the more reasonable it gets. Is that right?
Well, so let me try to answer in a couple different ways. There is another limiting principle in the sense that the benefits and harms that the mayor's agent is weighing, and that this court ultimately weigh, have to relate to preservation interests. That's clear from the case law, and it has to relate to those interests that are set forth in the statute. So the mayor's agent can't decide to make his or her decision based on other factors. That's what Preservation 1 is about, that case that DECA cites about the money aspects. In that Preservation 1, what happened is the the landowner tried to justify the demolition of a building by saying, well, it's going to be too expensive to renovate. And the court rightly said, no, so you can't include that cost in the analysis because that's not a historic preservation benefit or burden. That's just an economic cost that doesn't have anything to do with preserving historical assets. That's very different from what happened in this case, where what the mayor's agent rightly concluded is if you have a project that's going to, in this case, the subdivision, that's going to provide a stream of revenue that can be dedicated to making improvements and renovations of the temple so that it can remain, so that it can be improved and so that people can continue to enjoy it in the future, that's a historic benefit. So it's the fact that the money can and will be used to benefit the historic asset that certainly can be considered by the mayor's agent. Again, that doesn't mean, as Mr. Hayes suggests in his argument, that anytime there's money generated, it's automatically okay under the Preservation Act. That's simply one factor that the mayor's agent is supposed to consider. And I would also just, while we're on this point, I would add, this is not something that came up from whole cloth in this case. The mayor's agent has expressly recognized in prior decisions that exactly that kind of economic impact, when money is going to be provided by a subdivision that will allow preservation of a historic building, that is properly considered and can justify, that is a historic benefit that can be considered in the Preservation Act. And I'm talking now about the Cape Verde Embassy case and the Tregaron case, which are cited on page 28 of our, so you can look at those. And the importance of them, I think, obviously, is those aren't Court of Appeals cases, but this court should provide some level of deference or give some level of deference to the mayor's agent where he or she is interpreting the statute that he or she is charged to interpret. So, I think
Ronan, we've kept you here for quite some time. Do you want to wrap it up?
Yes, I will do that. I will just say I did want to address. I think this argument about the evidence and this construction website, we deal with this in our brief, but if you look at our brief in pages 25 to 27 of our brief, including footnote 13, you will see that there was substantial evidence. Number one, you'll see there's substantial evidence in the record that there is a lot of work that needs to be done to this temple. It wasn't just a 10-year-old report. There was testimony and a more recent letter and submissions from both Perseus and the Supreme Council established the fact that there's millions and millions of dollars of important work that needs to be done to this building. And I would add, with respect to addressing this website, yes, it's outside the record. Second, it's hearsay. And third, look at the website. It doesn't actually say what they says. It doesn't say that all that work was completed. It doesn't verify that all the work that is the basis of the testimony that went in front of the mayor's agent about the electrical system, the windows, the rotunda, all that work that needs to be done. It does not say that all that work has been completed. The record is uncontested that there is tens of millions of dollars of work that need to be done. There was no misrepresentation about that.
So assume that there's only $30 million of work remaining to be done. Does that not affect the mayor's agent decision?
I would say, I would say it does not change the result, because $30 million to a guy like me is a lot of money. And it is to most people. And even if that's where you end up and say, okay, let's assume that this website is correct and they did $50 million of work, $50 million worth of work, so there's only 30 million left. Even if you make that assumption, the fact that there's $30 million of work required to keep that building up to date and so that it can be preserved is still a sufficient, it still makes it sufficient for the mayor's agent to consider the fact that there's going to be substantial revenue stream that can pay for that work in the coming years.
Let me voice this question.
Sorry, go ahead, Judge Fisher.
Thank you. Let me voice this question, which you'll probably tell me is irrelevant. I would think the mayor's agent might have looked $80 million price tag. They're only getting $1 million a year stream of income. That's a pretty puny stream of income. And weighing that against the losses to the historic site, I'm not going to allow it. Is that completely out of bounds?
No, I don't think it's completely out of bounds at all. And I would never suggest that any question you ask, Judge, is irrelevant. I would say that analysis is entirely relevant, but I would say here the mayor's agent did it the right way because he's weighing all the benefits and all the burdens. Now, $1 million a year is not, it's not chump change. It's not $80 million up front, but it's not chump change on the one hand. On the other hand, you've got still on that hand, you've got other benefits that the mayor's agent recognized here. You're returning the lot to a size. Right now, this lot, before the subdivision, this lot 108 was bigger than any lot in either of these two historical districts. It's being restored to a size that's more commensurate with where it was historically, and also with the other lots in the historic districts. The carriage house, which is a contributing structure, is going to be incorporated into this project. So it's going to be preserved and put to use, which it's not being used right now. That's another benefit. So, and you'll see this in our brief, there are other benefits. Put all those together on one side. On the other side, what's the harm? You are exactly right. It is a harm in some sense that people from a certain vantage point are not going to be able to enjoy this nice view they have of the temple right now. But what matters, and this touches on a point I made before, what matters is the historic preservation benefit. Look at the statute, look at the Historic Preservation Act. It doesn't talk about views. And this is something that mayor's agent has recognized in decisions that we cite in our brief as well. Views across property that were not part of the landmark site when the landmark was built, that haven't historically been there, that park's only been there for about 20 years, and that where that land used to be taken up until 30 or 40 years ago with two and three story row homes.
But I
that's
think
not a protected interest under the
Mr. Ronan, I think we're getting sort of farther afield from what I thought Judge Fisher's question was, and certainly my question is about, what information needs to be considered by the mayor's agent. And I don't hear you denying that tens of millions of dollars of work has been done on the temple. And the record shows, that a letter was presented, in 2019 saying $80 million of work needs to be done. Now, that figure seems like there's a basis to think that figure is subject to question. And if in fact there's only $30 million of work that needs to be done, so that's less than half than was represented to the mayor's agent. And you're saying we need to defer to the mayor's agent's decision making and let them, exercise their reasonable discretion. I just think those propositions are in tension of like, never mind, quite how much money it was. $30 million is a lot of money to the average person. I mean, this is not about how much $30 million is to the average person. This is about how much money is needed in these large construction projects. And $30 million, I think that's kind of par for the course. So I guess I'm asking you to resolve, how can you resolve this tension between kind of pushing deference and yet not denying that the facts that were presented to the mayor's agent might have been inaccurate?
Mm-hmm. Let me try to address that. First thing I should say is I do not know how much work was performed by this construction company as is reflected by their website. I've not been in the temple. I don't know those facts. They're not in the record. And I represent the developer. I don't represent the Supreme Council, so we weren't involved in whatever work was done. I will say though, a couple things. If you look at that website, it's not clear that it's saying that $50 million of work was done. It's saying that construction company completed their work on whatever this is advertising for them, right? Whatever their $50 million project they were involved in. So they're saying we completed our work on this project, which was going to be a $50 million project. That's not the same thing as saying $50 million worth of work was done. What we're talking about here is just this one reference on this construction company's website. It does not establish that $50 million worth of work was done. And what is in the record here is firm evidence that establishes that there is substantial work that has to be done and that work is going to cost $80 million. So there's not a tension. It's not as though I'm conceding that $50 million worth of work was done and there's only 30 million. I was trying to answer in terms of even if you assume that. So if I was unclear about that, I apologize. Look at the record. What the record says is there is testimony and documents in the record that says, here's all this work that needs to be done. It's going to cost $80 million. It may be that before Gunley did whatever they did, it was $130 million, and now it's 80. So that's another way to make those things consistent. So there's nothing in that website that renders the record before the mayor's agent wrong.
I think the problem with that is, wasn't there a representation that no substantial work had been done on the property for however many decades? Right.
So,
and so, I mean, not to bring this in, in criminal cases, you might think of this as sort of newly discovered or, Brady evidence that you might have, you're saying this is the evidence that came into the record, but these witnesses were never confronted with the fact that, in fact, some substantial sort of renovation was done and some amount of money was spent recently. And so, yeah, the unimpeached record is what it is, but there seems to be reason to question that record.
Yeah, and I suppose that's perhaps where I break with that presumption, because again, all we've got is a statement on a construction company's website that they worked on a $50 million project. They don't say that they did all the work themselves. They just said, we worked on this $50 million project and we completed our work. So that doesn't tell you that $50 million of work was done. And it may be, I don't know what that construction company did. I have no idea. It's not that I'm not disclosing facts that I know, I have no idea. But it does not say, that evidence does not establish that $50 million worth of work was done. So it does not establish that there was anything misleading that was said by the Supreme Council or Perseus in front of the mayor's agent. And that's where I think, I don't think it would be a good thing for our system of justice if you allow opponents to development projects after a proceeding like this is done to come in and say, well, here's some website that, we're going to argue is inconsistent with the record, and there you got to do the whole thing over. That would not be a good precedent for this court to set. That's going to create all kinds of problems that I think is going to benefit anyone.
Thank you, Mr. Ronan. We will let you sit down now, and we will hear from Mr. Hayes in rebuttal. Mr. Hayes, you're muted.
Thank you. That would have been a fruitless argument otherwise. Let me address several points. First, as to Judge Deal's question about what Gondelman actually says, and it's a little bit different if you move a little longer further down the page from what Mr. Ronan was citing. It says this. This is on pages 1245 and 1246. Under this subsection, this is a subsection of the Act, alterations, it is insufficient to emphasize only enhancement to adapt a property for current use. Rather, the applicant must also demonstrate that the proposed alterations will retain and enhance the historic property so that it contributes to the character of the historical district. So it clearly says that those purposes are in the conjunctive, and indeed, had the legislature intended to put them in the disjunctive, it would have used the term or, which it did 211 times in the Act itself. Secondly, with respect to the deference due to the mayor's agent, with respect to the statutory interpretation issues here, that statutory review by this court is de novo. And also his, in our view, his position on these issues was contrary to Preservation 1 and Preservation 2 and Font 2, so that he's not entitled to any credence for interpretation for which he provided no support. Judge Easterly, with respect to your question about wouldn't it make a difference if there were less, $20,000 or something just left, and essentially the answer was, well, no, it doesn't matter. And that is the risk of the approach that the interveners in the district is having here. It's too much discretion that was never intended by the legislature to give to the mayor's agent. He said in his opinion and I'm citing now from footnote 7 on page 5 of his opinion. He said, providing a source of revenue through subdivision is consistent with retaining and enhancing the landmark because over time there is a cost to maintaining an historic structure. There is always a cost to maintaining a historic structure. That's why the legislature provided for 3 routes that you could take. And the route that they chose here is the one that, as Gondelman said, presents a heavy burden. With respect to Judge Easterly's point about, and Judge Fisher's point regarding whether the, isn't the time, doesn't it make a difference what has happened in the Temple Gardens area since the period of significance, which of course is under dispute as well. It's a question that will arise in the Superior Court case. The answer to that is that it matters tremendously to the boundary, and it matters, and the boundary dictates what requirements the interveners must meet. The Act says that it protects the temple and its site. And what the HPO said in its initial report before the developer's call was that the site of the temple, was the lot on which it sat when the act was passed in 1978, which was lot 820, which is what we contend is the boundary. That same point about goes to Judge Fisher's point about, well, doesn't the open space, it's not an historical, the contention of the interveners was it's not a historic preservation interest. Well, compatibility is an interest under the Act. It's specifically under the provisions of the Act that deal with historic districts. The mayor's agent here said that it was inconsistent because because open area is inconsistent with the area, inconsistent with the historic district, despite the fact that there's open area, Logan Circle, DuPont Circle are in the 16th district, and despite the fact that when the 16th Street district was actually founded, it incorporated the very vacant spot that we're talking about here. It's just incomprehensible that the mayor's agent would have come to that conclusion. With respect to McMillan, FOMP 1, as we say, the language in FOMP 1 is consistent that the downstream economic effects, refurbishing costs, cannot be considered. And I'll quote from that stat.
Mr. Hayes, we can review McMillan or FOMP decisions and the other cases cited in the briefs.
But FOMP,
so if you want to,
right,
if you want to bring your rebuttal to a close.
Yes. The statement by interveners that, well, he should consider the harm. Well, the problem here is he didn't consider the harm. He didn't consider the aesthetic effect on the temple. He said he didn't have the, that they're not entitled to views. But the point here is the aesthetic effect on the temple itself. And that's an interest that, as this court said in Barry, is protected under the Act. And finally, with respect to the efforts to find some way that the Grunley webpage didn't mean what it says, he said, well, that's 80 million. The 80 million figure was from 10 years ago. The webpage was in 2015. So, the representation to the court was that there was 80 million uncompleted. The Grunley webpage clearly says, it listed what was in the project. This was submitted in our motion to stay, what was in the project, and it said project completed, quote, project completed.
Mr. Hayes, with respect to the Grunley website, my mind keeps coming back to the question. If you think false evidence was presented to the mayor's agent, go tell that to the mayor's agent. What gives you the right to bypass him and present that evidence to us in the first instance?
We didn't discover that until it was already on appeal. It was already outside of the mayor's agent purview. This court had adopted our appeal. I think we were in the middle of moving to stay. So it was no longer, first of all, we had no discovery in the Superior Court case because that had been dismissed. The mayor's agent case had been resolved and it was on appeal. So that's why we brought it to this court.
Thank you.
All right, Mr. Hayes, thank you very much for your argument. Thanks to the other counsel who have spent quite some time with us this morning. We appreciate it. The appeal 28A 693 is now submitted, and this court will stand adjourned.
Thank you,
This
Your Honor.
court is now adjourned.